4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon to the lawyers in this case. I understand we have quite a few lawyers that will actually be looking in, so to speak, but it's only two lawyers going to actually participate. But anyway, good afternoon to all the attorneys that are involved in this case. Welcome to the Tennessee Court of Appeals. Your panel today consists of Judge Frison, Judge Davis, and myself, Judge McClarity. The rebuttal time has already been reserved, I understand. We have 5 minutes for rebuttal. Is there anything else we need to consider? Also, if there's any technical matters that come up during these proceedings, please let us know immediately so they can be addressed. You will be presenting your case as if you were actually in court, except you will not need to rise, stand during your presentation. Mr. Clerk, are there any preliminary matters?
No, Your Honor.
Then you may call the case, please.
In re SmileDirectClub, Inc., Securities litigation.
Thank you, sir. Are you prepared for the appellant to present your argument?
Yes, Judge McClarity.
You might proceed. Go right ahead.
Thank you, and may it please the court. My name is Scott Musoff from Skadden Arps, and I represent the SmileDirect defendant appellants, and I'm speaking this afternoon on behalf of all defendants appellants. As is well settled by this court, including in the Rogers versus Adventure House decision by Judge Frierson and joined in by Judge McClarity, a class action is not a matter of right, which may be demanded. It's a procedural privilege. And while federal courts often find claims under the securities laws suitable for class treatment, the law in this state requires the Chancery Court to have undertaken a rigorous analysis to ensure that plaintiffs have met their burden in proving each of the prerequisites for class certification. Today, I'm going to be focusing on one of those prerequisites, the typicality prong of class certification. While typicality relates in part to the defendant's conduct and plaintiff's claims, another part of typicality relates to whether there are any unique defenses as to the proposed class representatives. And as stated in the Rogers versus Adventure House decision, the claims or defenses of a class representative are atypical if a defense unique to that person or a small subset class is likely to become a major focus of the litigation. I'll now turn to describe the unique defenses that both of the proposed class members are subject to. Both Mr. Mancourt and Ms. Vang are subject to the unique causation defenses, what we'll talk about in a minute as in and out trading, as well as standing to pursue some of their claims. So pause for a moment on the causation defense, and I'll get to this again in a moment, but whether it's meritorious or not is not the subject right now. The question is whether they're subject to that defense so that it'll become a focus on the litigation, even if ultimately it's not meritorious, although I do believe there's very little dispute here on how the causation defense would work under this circumstance. In a securities case such as this, plaintiffs allege they bought securities, in this case, the stock of SmileDirect, while it was inflated due to alleged misrepresentations or omissions made by the company. They then allege some later point in time, there were supposed revelations or curative disclosures that caused the stock price to decrease, hence causing damage to those that bought and held through those disclosure dates. Here, plaintiffs allege 4 such supposed revelations, 4 such corrective disclosures. The first being September 24th, 2019, when a lawsuit was filed against the company alleging false advertising. The second was when California passed certain legislation, October 14th, 2019. The third was when SmileDirect itself sued the California Dental Board a few days later on October 17th, 2019. And the final one was SmileDirect's earnings release for the third quarter of 2019, which was issued on November 12th, 2019. So now let's take a look at the two proposed class representatives. First, Mr. Mancor, a quintessential in and out trader, meaning in at a point in time and out before any corrective disclosures are made. He bought his shares on the very first day of the IPO, not in the IPO, but the first day, for less than the IPO price, and sold them as soon as the market opened the next morning for a loss. I think about a $100 loss he suffered in total for his entire investment. He's held the stock for less than 24 hours. No adverse revelations made in those 24 hours. He is a quintessential in and out trader. Ms. Vang held her shares a little bit longer, but not through that earnings release in November of 2019. She sold her shares before the earnings release in November 2019, the only one of these supposed revelations that wasn't based on otherwise publicly available information. So now, faced with those defenses of causation, why does it matter? Why is it going to be a focus of the litigation? Well, it's already been a major focus of the litigation, but it's only going to become greater. Expert testimony as to who suffered losses and when. Mr. Mancor is going to argue that alleged improper inflation came out on the very first day. Nobody else in the class wants to argue that, but they're going to have expert testimony and fight over experts as to whether they could actually make that claim. Risk of losing credibility. Same thing with Ms. Vang. She's not going to be. She's going to have no incentive to provide alleged inflation coming out on that last disclosure date, the financial statements. What happens if defendants make an offer to settle this case, but only on losses allegedly due to the financial statement disclosure? Neither of these plaintiffs would have any incentive whatsoever to accept or even consider that settlement. Yet that might be in the best interests of the class, where somebody who held throughout the entire period of time can objectively determine some of those things. And neither Chancellor Perkins nor plaintiffs deny that these are in or out traders. There's no dispute as to the underlying facts. There's no dispute as to the underlying defense. Instead, plaintiffs urge this court to simply disregard this fact, as the Chancery Court did, either as premature or irrelevant. That's on pages 21 to 24 of their brief. Specifically, they contend that plaintiffs' purported status as in and out traders is irrelevant to typicality, and it's a merits-based question not properly before this court at this stage of the proceedings. As Judge Broderstein held in the Rogers case and the Roberts case, and also this court held in the Roberts case, Roberts and Rogers, both cases, it's the exact opposite. This is a quote: "At the very least, issues concerning the existence and application of these asserted defenses are likely to become a major focus of litigation, regardless of whether they are ultimately meritorious." So it is an issue right now. The Supreme Court also, in the Goldman Sachs case, made it very clear that to the extent merits overlap with the prerequisites of Rule 23 and class certification, this court can delve into it. Plaintiffs argue that the Roberts
Mr.
case
Messoff,
is...
let me interrupt you
Yes,
real quick and ask you about the case that that your opposition cites, which is the Cosby case, where they say that the Supreme Court held that the plaintiff does not need to prove loss causation at the class certification stage.
Yeah, yes, Judge Davis. That is true. We're not arguing that in both of those cases, neither one involved a class representative that was subject to unique defenses. What the defendants were arguing there is to satisfy class certification, you need to prove loss causation, or you can't get a presumption of reliance under the fraud on the market theory, or otherwise the claim fails. And in fact, they cite both the Cosby case and Direct General for that point. Judge Campbell, who authored the Direct General opinion from the Middle District of Tennessee, in a subsequent case, Beach versus Heathways, which we cite in our brief, what he said when plaintiffs tried to make the same argument with him in a subsequent case, he said, no. In Direct General, this court considered the availability or applicability of the fraud on the market presumption and determined that the plaintiffs had established for purposes of class certification, that the presumption would be available. He then goes on to say that the defendant's challenge had to do with whether individual determinations of reliance would be required, not whether the named plaintiffs were subject to unique defenses. In fact, plaintiffs do not cite one case where the proposed class representatives were subject to in and out unique defenses, and they were certified as being both typical and adequate to represent the class at the time. And indeed, that's where Chancellor Perkins was led astray. He followed plaintiff's view that all he had to do was argue that because plaintiff does not need to prove loss causation at the class certification stages, individual purchases and selling differences don't destroy typicality. Again, that is very different than the unique defenses that are going to subsume this litigation. Very briefly, I'll touch on the standing point. On the standing point, there is, again, no dispute that neither of them have standing to bring a 12A2 claim. Instead, they rely on the New Jersey Carpenters case, a district court case from the Southern District of New York, to say, that's okay, class representatives don't need to have standing for all claims. That is contrary to the law here. That is contrary to this court's decision in Wofford, where each claim must be analyzed separately and each class representative must have standing. Thank you.
Thank you. You have your rebuttal left. And for the appellee.
Thank you. May it please the court. My name is Jerry Martin of the Nashville Bar. I'm here on behalf of the plaintiffs' appellees. I'd like to start, if I could, just to give the court just a very brief description of the statutory framework that's relevant in this case. This is, of course, a securities class action that's brought under the Securities Act of 1933. And the Securities Act, it allows investors like Mr. Mancour and Ms. Vang to bring claims for losses that are associated with material misrepresentations or omissions made in the offering documents for publicly traded stock. It is and this is important for the analysis of class certification, it is a strict liability statute. And it is not a fraud statute. We are not making allegations of fraud. The allegations of misrepresentation can be negligent misrepresentations. And so it's not necessary under the Securities Act to show reliance. And that's very important, I think, in the context of any class certification decision. And specifically, it's not necessary for an investor to have even read the offering documents that are in question, or to have relied upon them in any way to assert a claim under this Securities Act. So I say all that in the context of the fact that cases brought under the Securities Act of 1933 are tailor-made for class certification. And we don't take it for granted. We're not, we know the decisions, the state court decisions that Mr. Musoff cites. We meet all of the elements of Rule 23, but we do think it's worth pointing out that courts across the country have overwhelmingly recognized that the Securities Act, because it's a statute that involves strict liability with the primary element of whether the offering documents contain materially untrue or misleading information, that they are particularly well suited for class certification. Judge Davis mentioned the Cosby decision. That is certainly one of the primary decisions we would direct this court. We have a number of Securities Act decisions that based on that are certification decisions that we rely on that are not just across the country, that are right here in Tennessee, Cosby being one of the more important ones. But the court in Cosby noted, and I'm going to just read one sentence from that decision, suits alleging violations of the security laws, particularly those brought pursuant to sections 11 and 12A2 Securities Act cases, are especially amenable to class resolution. Of the 62 cases that are cited in the defendant's opening brief, I think only 6 of them deal with certification claims brought under the Securities Act of 1933. And of those 6, only about half of them resulted in the denial of class certification. So the authority is overwhelmingly in favor of certification, and it's because of the formulaic nature of the Securities Act.
Let me back up
Yes,
just
Your
a
Honor.
second and ask you, and I'll just be candid. I don't pretend to be an expert on securities litigation. So I'm going to have to do a lot of research on these particular issues. But are you saying that there's strict liability in the sense that all that's required is to show that the IPO contained false or misleading information and that there were subsequent losses? You're saying it does not matter if the people who purchased stock read, saw, relied on at all the allegedly false or misleading information in the IPO offering?
That's correct. Strict liability. That is correct, Your Honor. And when I talk about strict liability, I'm really going to what's the intent of the defendants. So here we don't get into whether or not it's not a fraud case. We don't get into whether these were. There's no scienter requirement. But you're right. Reliance is not an element. So it's not necessary for a plaintiff to have read the offering documents. It's not necessary for a plaintiff to have relied upon them. And that really goes back to sort of a bedrock principle in securities litigation of just the principle of reliance and the fact that it's assumed in an efficient market with thousands of people buying and selling stocks that all of the public information about a particular stock is sort of baked in to the price of that stock. And so that's sort of a fundamental kind of underpinning of the concept of reliance in securities cases. But in Securities Act of the 33 Act claims reliance is not an element of the case.
But there is a causation defense.
There is a loss causation defense that goes to the merits. That is correct.
You're saying that we shouldn't consider that at all in determining class certification.
No, you shouldn't determine it at this stage. It's not relevant at this stage. And that's because loss causation. Well, first off, let me just back up and say we disagree. Mr. Musoff says we don't dispute that the plaintiffs here are in and out traders. We absolutely dispute that Ms. Vang is an in and out trader. She bought her stock on the day of the initial public offering, and she held it for 6 weeks. And the only corrective disclosure that she sold her stock before it came out was the third quarter earnings. She held her stock when it came out that, for example, they did not disclose that the state of California had conducted simultaneous raids at 3 locations to investigate whether or not SmileDirect was practicing dentistry without a license. That happened in 2008. That news came out in subsequent litigation after the IPO. Ms. Vang held during that time period. She held as it became known that there were these practices at place at SmileDirect to require disgruntled customers to sign non-disclosure agreements. All the while in the offering documents, they're touting their customer satisfaction, yet they don't disclose the extraordinary measures they're taking to suppress anyone who is unhappy or dissatisfied. She held during the time period before.
Well, she did, but the other guy was clearly an in and out investor.
Mr. Mancour did buy and sell on the day of the IPO. At the same time, we still think that the questions, though, to your other question, Judge Davis, as to whether that's even something that should be considered here, it's not a typicality. We don't think it's an appropriate typicality argument, because really at the end of the day, loss causation is an argument that there are other things other than what caused the stock to drop, other than these disclosures, these corrective measures. That's going to apply to all of the class. They're going to be able to make those arguments as to anyone who bought or sold SmileDirect stock associated with the IPO. So we don't think it's an appropriate typicality defense or appropriate analysis under typicality. It really goes to the merits. It's an affirmative defense in the case. On their standing question, Mr. Musoff spent a little bit of time talking about standing. The question there is whether or not Ms. Vang and Mr. Mancour can represent a class of individuals who bought stock directly from the defendants. We don't dispute that they didn't. They did not buy stock directly. They bought stock in the secondary market, like the vast majority of, or like all retail investors would have. The issue there, and as other courts have affirmed, is whether or not they can bring those claims on behalf of Section 1282. And other courts, which we cite in our brief, have said that they can. And the argument there is that they're common issues. It's the exact same. It's the exact same claims. They're identical claims, regardless of whether you bought the stock from a platform like Robinhood, or if you bought the stock directly from an underwriter. So it's not, again, and that's really another question, and what courts have uniformly said about that. That is a merits question standing, and I think that this chancellor noted that could be something that they could raise later on in the case, and it's often a subject of summary judgment. I would like to be remiss if I did not address, which Mr. Musoff, for whatever reason, has chosen not to address today, the adequacy arguments. About half of their brief is related to the adequacy of the plaintiffs, and I want to address that really in this context. The question before the court today, the fundamental question before the court today, is: are the interests of the absent class members being protected and being well represented by the class representatives and the appointed class counsel? And I think it's a resounding yes is the answer to that question. And that's really what adequacy goes to the heart of. And often adequacy and typicality are sometimes the flip side of the same coin. And really what the courts are looking for and trying to get to the bottom of, is whether or not the class reps and their counsel will adequately represent the interest of the absent class members. They make a number of allegations in their opening brief, to their credit, that were untrue. To their credit, they backed off of those on the reply, and I appreciate that. The thrust of their adequacy arguments really are two things, and they're in many ways very related, in the same vein. And that's that Ms. Vang and Mr. Mancour are not knowledgeable about the case. And, that really conflates sophistication as an investor with the adequacy standard. And they aren't the same. And another case, in addition to Cosby, that I would highly recommend to this court, is another Tennessee case, another Securities Act case, and a case just like this case, where you have retail investors, small investors, seeking to certify a securities class action. And that's the Stein versus U.S. Express case. And last year, Judge McDonough in Chattanooga certified the case. And on this issue of the sophistication or knowledge and the level of involvement of the plaintiffs, Judge McDonough said that plaintiffs as laypersons cannot be reasonably expected to understand the deeper legal intricacies of this matter. He went on to say that they were engaged, they were involved, and they plainly intended to see that the defendants' rights would be, that the alleged wrongs would be righted. And that's all that Rule 23 requires. And that's true here. And so I think that's an important case that I would recommend highly to the court. Here, the evidence in the record is that both Ms. Vang and Mr. Mancour are highly engaged. They read the complaints before they were filed. They were able to give detailed answers to what the case was about. They're committed to the litigation. They produced documents. They sat for depositions. Ms. Vang answered a question about the procedural history of the case. The counsel for SmileDirect, told her that was a pretty good answer. Complimented her response about her understanding of the process. These aren't absentee class representatives. The second vein is that this is just lawyer-driven litigation. And in their zeal to make those points, they argued that we solicited these clients. That did not happen. The record doesn't support that. It's a loaded term. No one was solicited. They did internet research and found lawyers. That's not solicitation. They said that they implied through a half-truth that we filed this complaint. Ms. Vang's complaint was filed without a signed retainer. That was untrue. That's not true. They know it because we produced her retainer agreements. We waived the privilege. And so fortunately, they backed off those kind of allegations in the reply. But again, the point is, the question before the court is, are we adequately representing the class here? Are Ms. Vang and Mr. Mancour and her lawyers? And that's what the court should be concerned about. And, we have defeated a motion to stay and a motion to dismiss. They have appealed those to this court. They've said, no, this case should be stayed because there's a federal case that's just sitting over in federal court with a pending motion to dismiss and with discovery stayed. The Court of Appeals denied those motions. It affirmed the trial court. The Supreme Court did the same. We've gotten into document production. We've gotten the class certified. Here we are today. Are we adequately representing the interest of the class? Are Ms. Vang and Mr. Mancour adequately engaged? The answer is yes. And so I know Mr. Musoff didn't address adequacy, but I just think that, the defendants here, they might not like the securities laws. They might not like class actions. They might not like state court, and they might not like small-time investors and the lawyers who represent them, and that's fine. But the innuendo and the allegations of the nature of this litigation is inappropriate. At the end of the day, the class, whether it's a typicality or an adequacy argument, the question before the court is, are the interests of the absent class members being represented? We can litigate loss causation, standing, all of these merit questions down the road. The answer to those questions is yes, and we would urge the court to affirm the trial court's decision. Thank you.
Thank you, sir. Your rebuttal, sir?
Thank you, Judge. My friend's argument, I think, teed up the legal error that occurred here on class certification perfectly. Both Chancellor Perkins and plaintiffs urged this court to say you can never address the defense of negative causation that may be unique to a class representative because it touches on the merits. That's contrary to the law in this state. That's actually contrary to federal law as well. But that flies in the face of this court's decision in Rogers and Roberts. In fact, in Rogers, causation, it wasn't a securities case, but causation was the very defense that the class representatives were subject to. And that subjected them to the unique defenses. That's exactly why this is legal error. This is not a question of discretion for the judge's determination of balancing facts and whether this will be an adequate class or not. This is pure legal error that Chancellor Perkins said, I can't touch loss causation at the class certification stage because plaintiffs led him to that result. That's contrary to the law. It's not tailor-made for class certification when the only two class representatives they could find to bring this case is somebody who sold their stock after one day for a $50 loss when there's no alleged corrective disclosures being made. How is that person identical to the class? How will that loss causation argument rise and fall for the whole class? And Ms. Vang, while they suggest she's differently situated, is really no different. How is she, who sold her stock on October 29th, going to be raising the same claims and subject to the same defenses as those that held their stock through the disclosure of the company's earnings statements weeks later in November? These two people are subject to unique defenses. And then coupled on top of that, there was no backing off of anything. We pointed out the facts that these are two people that responded to ads for lawyers to bring a suit. Not ads by these firms, Mayu. They didn't even know who the lawyers on the papers are, didn't know why there were 5 firms on the papers, never really heard of them when the complaints were filed. These aren't the lawyers whose ads they responded to. And yet, Mr. Mancour, who sold the stock on the first day, is going to be the one who accepts or rejects strategies relating to losses that may have occurred through 4 subsequent disclosures, or Ms. Vang through the earnings disclosure. There is not one single case they cite. And maybe they could cite 60 cases where cert was granted, because in none of those cases did people try and present class representatives that suffered from these unique defenses and these unique defects. Turning to standing for a moment, we didn't hear one thing about this court's decision in Wofford or its progeny. It is black letter law, in this state that each class representative has to have standing to pursue the claim. They conceded neither of these class representatives have standing to bring a Section 12A2 claim. In their papers below, yes, sorry, Judge.
Don't let me disturb you, but hold up for just 1 minute. Mr. Hibner, look like our clock is frozen on us. Mr. Hibner? There we
Here
go.
we go.
Go right ahead, sir.
Thank you, Judge McClarty. So there's no dispute that neither of these proposed class representatives have standing to pursue a 12A2 claim, which is somebody who purchased directly in the offering. While, yes, some district courts outside of Tennessee have certified a class where the representative only had a Section 11 claim, that's not the law in this state. In fact, they cite a Southern District case, New Jersey Carpenters. Several years later, Judge Forrest in the Southern District of New York dismissed claims where neither class represented. That's the Stadnick versus Vivint Solar case we cite. So that can't change the law in Tennessee, Your Honors, that each class member must have standing. And I would say that what their argument would suggest is every defense goes to the merits. That's the nature of a defense. So I find it irreconcilable to say that you can't assess whether somebody's subject to unique defenses, which, as Judge Frierstein said, is exactly what you have to look at to determine typicality. Is the defense that's subject to these two class representatives or a small subset of the class? Doesn't have to be just these two. Is that atypical? Is that going to be the focus of litigation? That's clearly going to be the focus of litigation here. And for those reasons, we respectfully submit that this decision granting class certification should be reversed. Thank you very much.
Thank you. I want to thank the attorneys for your presentation. Your case has now been submitted to the court. Hopefully you will receive our order and opinion within a reasonable period of time. Thank you very much. If there's nothing further, Mr. Hebner, will you please adjourn court to the next calling of the docket?
This honorable court is now adjourned.
The attorneys may be excused.